Before we could talk about crime, murder, theft, rape, stealing, and so many other offenses you could ever think of, the important question and fundamental question we want to answer is what is crime and what is the nature of criminal law. This topic is very important because, like we all know, criminal law is a distinct aspect of law, different from civil law. So it comes with a lot of issues, it comes with a lot of challenges, and that is what basically today's video is all about. Many people have asked me to make video on criminal law, to talk about so many concepts like criminal responsibility. I hope you know that for the fact that somebody killed doesn't make the person, culpable or guilty. There are so many things the court ought to consider before you say that somebody is guilty of murder. Unlike any other civil this thing where you can just prove based on balance of convenience and all those things. Here, it's not just enough to prove beyond reasonable doubt, because even the defense or the accused have something to say. Yes, I killed somebody. There could be reason why I killed somebody. So these are what we regard in the criminal law as what? Criminal responsibility. It's trying to tell you to what extent can somebody be liable and to what extent can somebody not be said to be guilty of an offense, even though the person may have killed, so to say. So that is what basically we want to do in this video. By the way, my name is Kingsley Ifeanyichukwu, better addressed as King's Advocate. I'm currently a 400 level law student and the founder of Law Made Simple. What I do on this channel is to help law students in the challenges of becoming tomorrow lawyer. If this is the first time, I encourage you to subscribe and turn the notification, because every Friday, Saturday, and Wednesday we used to post a video here that could be relevant to you, and you'll be the first people to watch it. This is New Year. This is my first video 2026, and I must encourage some certain individual who have been encouraging me too. Those people who have been commenting, those people who have been liking my video. I want you to know that I love you so much. Because I don't want videos to take long, I will not recognize your name today, but on my live tutorial coming out on 10th January 2026, I'm going to mention each and every one of you to encourage you and to say thank you for always saying thank you. Another thing is to do good to people, and another thing is for them to appreciate. For few of you that have been appreciating, I really appreciate you too, and you're encouraging me to do more. As a matter of fact, I'm doing this video based on the response from Splendid, who asked me to make video on nature of criminal responsibility. Although this video will touch it a little, then the next video we will discuss it fully. So welcome, and let's do justice to this topic. You will really enjoy it. So without further ado, let's begin. What is a crime? A crime can simply be defined as an act or omission punishable by the instance of the state. Or you can say a crime is an act or an omission prohibited by law and punishable by the state. As we progress, basically, I'm going to tell you everything you have to know about criminal law. The only thing I want you to do now is to keep good attention. Let's do this together. And at the end, you'll find nothing difficult about criminal law. So the first thing now I want you to know, looking at this definition, obviously, I will say that criminal law is just that aspect of law. Basically, you won't be bothering yourself as by definition, because the definitions you ought to know have to be in your head. You have to master criminal law by knowing how criminal law works. That is enough. So unlike contract law, where you'll be required to define, provide authority defining contract and all those, criminal law doesn't have anything to do with that. But your understanding of the definition itself is the first stage of wisdom. So we say that an act or omission prohibited by law and punishable by the state is what we regard as what? Crime. From this definition, three key elements immediately stand out. So you see that there must be an act or what? An omission. 2, the act must be prohibited by what? Law. Very important. That is what majority of us don't know. This is where law is different from morality. So for the fact that something is immoral, or for the fact that something is not socially acceptable, doesn't make it a crime. This is what we regard in law as what? Nolem criminum pone sine lege, meaning that act or omission which is not written down to be a crime cannot be a crime. If you go to section 36 sub 12 of the 1999 constitution, you will see what I'm talking about. Even if in your own constitution, both the constitution of Kenya, constitution of Ghana, constitution of India, all of them have the provision that what? without a written down law prohibiting a crime, there cannot be what? A crime. This is first thing I want you to understand about criminal law. So if you are presented with a problem questions, the emphasis should be whether that problem question what supports an assertion, whether that problem questions the lecturer have given to you there is a particular statute prohibiting such an act. Once there is no column, once there is nothing written down about it, like the lecturer didn't give innuendo or express fact that shows that that thing is a crime by virtue of a law, please don't make it a crime. Don't create a crime where there is no crime because you are a redeemed Church of God member or because you are a mountain of fire or Jehovah Witness. That does not arise. Crime must be what? Written down. Once it is not written down, as far as the Constitution and common law is concerned, is not a crime. Are we good to go with this? So believe you have not noted this definition as per criminal law, because it will guide you in everything you are going to do. Then on the three elements, the act must be punishable by state. So what this one is trying to tell you is that I think I'm dealing with criminal law students majorly and some element of legal method and legal system students. So what this thing is trying to say is that it must be something that is punishable by instance of the state, meaning that as an individual you don't institute an action. I think it is a treaty law we all have taken judicial note of, that an individual doesn't institute an action as far as crime is concerned. We are told that you can obtain a fiat from the Attorney General, but based on the King's Advocate knowledge so far, based on the cases I have studied throughout my year in 300 level and so many other things when I was dealing with criminal law, I have never seen a place where an individual maintained an action as far as Nigerian is concerned, and even common law. So it is the state that does what? That prosecute. And state here doesn't refer to Enugu state. State here doesn't refer to Lagos state or Rivers state or Ogun state. It basically refers to what? A nation, a sovereign entity. So this is what the crime is all about. And now let us talk about the nature of a crime. So we have understood what a crime is. Then another thing we ought to know about crime and criminal law is that crime is punishable and not compensatory. Remember, what we are treating today is the nature of crime and criminal law. So we are trying to understand how criminal law works, because it will be a very added advantage when we proceed to heavy topics involved. So one thing you ought to know is that crime is punishable and not compensatory. What do we mean? When we say that crime is punishable and not compensatory, we are simply saying that unlike civil wrong, where the aim is compensation, the primary aim of criminal law is what? Punishment. So there is no case you will see in criminal law whereby at the end they will reward you because you win the matter, because the state win the matter, or because the accused win the matter. It doesn't exist. It doesn't work that way. Although the only exception to this is if you go to VAPA Acts, which basically was a provision that came into force in the year 2015 to take record of rapes. VAPA Acts, if you are part of my community in LinkedIn and was channel, you will see when I discuss rape most often. So you will see that VAPA Act, by virtue of section 1, provided for rape, the punishment and everything, but it went further to provide for what? Compensation. So VAPA Act is an exclusion or an exception to the rule that in criminal law you don't get compensation. What that provision made, this was the only criminal law I have seen that made provisions for what? Compensation. So this one is saying that if you are convicted for raping a girl, at some point the girl, if the girl have suffered harm, if the girl have suffered damages, and the girl can claim some damages once his matter succeed, criminally speaking. So what we are trying to say is that criminal law is not about compensation. It's about that if you lose, it will come with what? Punishment. If you win, it will come with just justice, that the person that wronged you is now behind the bar suffering, eating agbado in the morning and eating ewedu in the evening and eating the other cassava in the night, according to our learned Tinubu. So this is what criminal law is all about. Nothing compensation, everything is what? Prohibitory and prescriptive, and punishing and sanctioning all are what? Involved. Then the general rule in criminal law is that punishment could be what? Fines. So for the fact that punishment doesn't mean only staying in jail. Punishment could be fines. Punishment could also be what? Community service. There are some certain offense you commit in criminal law and criminal code. Your punishment is to render public service. Some, they will cane you if it is under penal code. There are some certain offense you will do, they will cane you mercilessly to correct your brain, all those things. If you commit a affray, that is fighting in the public, it could attract caning. These are the ways, these are the punishment that are provided. So it could be monetary, that is fining you. It could be jail. It could be imprisonment for life. Murder is the greatest offense one can commit. So it is known as capital offense. It comes with what? Sentencing to death. So if you have committed some person to death by killing him, you too, you'll be committed to death by sentencing you by virtue of section 316 of the criminal code. So this is what criminal law is all about, going with punishment. Then another thing I want us to talk about is the criminal responsibility that are surrounding crime. In the preamble of this video, I told you people that not all crimes, even if you have committed it, like it is obvious before the court that you have committed it, that you go in for it. What I'm trying to say in essence is that for you to be convicted of a crime, the court must check what? Your level of criminal responsibility. This is where we are going to then see whether the person is capable of understanding their action when they were committing that crime. Was the person aware of what he's doing? This is where the doctrine of mens rea and actus reus comes in. And you have found yourself favor, because this channel, I'm going to analyze all this thing one by one. This thing I said is not just enough. I have to go detail, give you cases, tell you how we are going to analyze them. So these are the things I'm going to do in this channel. The only duty you owe to yourself is to subscribe and turn the notification to all notifications so that you'll be able to be receiving the update when it drops. Remember, we are talking about what? Nature of a crime. I talk about the first one, that what? You must be capable to appreciate what you are doing. So if you are killing Mr. Kingsley, you must be aware that you want to kill Mr. Kingsley. There is more to this other than this, but we shall cover it. Then another one, what is what? The legality or the legal responsibility of your action. What this one is trying to say is there are some certain exemptions or presumptions the law has made in favor of the accused. One of them is what? Section 27 and section 28. That one talk about insanity. Under our law, the law presumes that everybody is insane, except if the person claiming that he's not insane can prove that he is insane at the time he was committing that crime. Let me just take myself again. The general presumption of law is that everybody is sane. That is, you are reasonable. But if there comes a situation whereby you are claiming that you were insane when you were doing what you are doing, the onus of proof then moves to you to show that you are actually insane, no longer the prosecutor. So the prosecutor is proving that you have killed somebody. You are alleging that though you accept that you killed somebody, but you were insane when you killed somebody. Then the court is then telling you, okay, tell us how you were insane when you killed somebody. So this is what we are talking about, criminal responsibility. Under criminal responsibility, we are trying to show that the person have actually killed somebody. He has accepted though. But he's saying that even though I killed somebody, there was something behind my killing of somebody. May Lord look into my case properly. So this is what criminal responsibility is all about. He's trying to tell you, to what extent can somebody be liable? To what extent can somebody be guilty of a crime, even if it happened? We then talk about defense of immature age. So immature age is another critical thing the court look at. So a person that is below particular age cannot be criminal responsible for a particular act. Under criminal code and penal code, the age is not stable. Under murder, if you have not attained that age of 17, you are often deemed as not capable of committing murder. Then if you go further, you will see talk about rape. You will see that there are times when somebody that is, not up to 7 years and not something that is not up to 12 years cannot be, deemed responsible to commit a particular offenses. I'm still going to treat this thing one by one. But I'm laying foundation to tell you how the nature of criminal law works. This is like a general knowledge. Then the subsequent video on this channel will treat each and every one of them one by one, section by section, authority by authority. Are we together? Kindly like this video. Like this video. I encourage you to always be liking the video. That is the only way you support. If there is anything like consideration you are giving, it is you liking it. Liking the video does two things. Two, it helps YouTube to know that the video deserves to be surfaced on the platform. So without somebody liking the video, you will not be able to see it on your own page, and it couldn't be beneficial to you. So, but if you like, the YouTube will notice that they are machine, they are not human being. That is the only way they track people, that people need this video, they will push it to other people. And what then do you think I'm doing here? You think I just came here to speak to two persons? No. It creates more that people will learn, because I'm here to deliver knowledge. And it pains if it's only few people that got the knowledge, when I know that I pour my energy to explain. So like the video. I don't want to be begging like this. But if you want me to be begging, I'll beg you. The law, like the video. Let's continue. Another thing in addition to this is what? Self-defense. Criminal responsibility, apart from insanity, apart from a bona fide claim of right, which we are going to talk about section 23, and then apart from what? The general talking about intention, mens rea, recklessness, and so many other aspects of intention, that is element of crime. Another thing again the court will check before they can convict somebody of crime is what? Absence of defense. So defense means that if you are killing or if you are fighting in defense of yourself, you could be absolved from any criminal responsibility that will come or that will ensue. Although there is application, all these things are point and have a way to work. That's why we are going to consider all of them single by single, because it's not just enough for you to say that you are defending yourself. Somebody came to attack you with this thing. Let us assume this thing is a rod. You want to come and choke you in your bed, and then you wake up and then pick your pistol or your barrel from your behind your bed and shoot the person. You can call it self-defense. The proportionate of the weapon the person is coming to attack you must be proportionate or must be equal to that you are using to attack him. So if somebody will come to attack you with cutlass, there is no justification for you to use AK-47 on him. We shall still discuss this in full to see how it works. Then another thing I want you to also talk about is this. It is mandatory and prohibitive in nature. So if you go to criminal law, you'll be seeing something like shall not. It is an offense. Any person who does. Shall not. It is an offense. Any person who does. These phrases simply suggest that this thing is not if you like, my lord. It is whether you like it or not. So criminal law is what? Prohibitive and mandatory in nature. Apart from being mandatory, apart from being prohibitive, it is not a crime. So it must be something that there is no discretion to do or not to do, or that exempts you. So once you have committed it, you are going in for it. Then there is also the other thing you have to note about strict liability offenses. The strict liability offenses is the only offense that will do away with all these things that are pointed out. All these things are pointed out, like intention, actus reus, and all those things. What strict liability means is that once you have committed this crime, whether you like it or not, whether you are intentional or not, whether you are insane or not, whether you are happy or not, it doesn't matter. Provided the state to say that once you have committed this crime, it is a crime, you are going in for it. So strict liability offense is often interpreted by the warden of the statute. Most often, many offenses are not. There are only few offenses that are strict liability offenses, because the court and the law knows the importance of what? Giving people the opportunity to defend themselves. But strict liability offenses often doesn't come with defense. There is nothing like I was insane. There is nothing like I was not aware. There is something like I didn't have intention. Once you commit the crime, you are going in for it automatically. So strict liability is often vague and most often not applied in our statute. And the courts have said that in the absence of true intention of the legislature to make something a strict liability offenses, the issue of the court will hesitate to interpret an offense as meaning strictly in liability. And I would like to tell you also that another important thing you ought to know about the nature of criminal law is that it works in a definite boundary. It works in a defined territories, meaning that unlike civil law that are wider in application, criminal law is restricted. If you come to Nigeria, for instance, Under our criminal code is what governs those in the south. Penal code is what governs those in the north. This thing means that you cannot charge somebody that are committed a crime in the south based on the offense that are in the northern penal code. If somebody have committed crime in the south, it is the criminal code that will apply only to the extent that criminal code provide for that offense. What this thing means that if you are charging me, I'm from the south, I'm Kingsley, I'm from Enugu State, I committed a crime in the northern part of the country. If you are charging me now, you are not going to charge me based on the fact I'm from south and then try to rely on section 319 and 316 of the criminal code. Rather, you are going to charge me by virtue of section 221 of the penal code, because these are, I committed the crime in the north, and the law that governs the crime in the north is what? The penal code. So if you make a wrong charge, the court is going to strike out your case and leave the person that ordinarily should be behind bar free. So this is how it works. The crime will strictly be adjudicated on the place it has been committed. Now let's look at the popular case of Aoko and Fagbemi, for instance. We all know that crime, adultery as a crime, is not applicable in the southern part of the country. But under the penal code, it is a crime. So Aoko and Fagbemi was decided, Aoko was exempted on that fact, of the fact that this thing happened in the south. And you cannot use because it is a crime in the north to convict him. Because section 36 sub 12 is paramount that the crime must be written down. Section 36 sub 8 is also paramount that the offense, no person can be punished for a crime that has not been in place when he committed that act. That is talking about retrospective legislation. And also section 49 of the Constitution also discuss this. So here I want to let you know that the next video that will be coming will basically have to be treating all these things one by one. I am doing this to help you, and I encourage you to click further video here that will be beneficial to you. These videos will definitely help you achieve excellence. I want you to know now that the only way you support us is by liking our video. If you have not liked, like, and then share with your classmates. We learn together, we grow together. So I will see you on my next video when I will be discussing what element of crime, mens rea, actus reus, and all those things. King's Advocate is here for you. If you have questions, please ask on the comment section.